Alrighty, read this one more time. This is just We the People News. Okay, I'm not an attorney. I'm not giving legal advice. Okay, this is educational purposes only. All right. Never look straight forward. Always look around to be able to protect yourself by any means necessary, people. All right. And how many times do I have to say, I'm not an attorney. I'm not giving legal advice and all that? Why? Because that's what they want you to go to them for, right? And bound yourself into their uh, process. That's why they do it, people. And even when they're pro se or all this, you're entering a kind of a criminal box. And they cannot stand people actually standing on their rights in their club. All right. So we need to wake up and realize that we need to kind of pull back away from them and just take our chances. Okay. There's going to be side effects. I'm under the belief and do believe that it's kind of a criminal activity thing. I may be wrong. Okay. Um, but the way evidence has been pointed, just the way it's showing. All right. This is going to be part 2. And
Now I start.
let's go up here. Let's see. Whoops. All right. So it's this right here. Okay. Capital S, capital N, capital A, capital F, capital U, radio. All right. This title is going to be Randy Kelton suing all judges in Texas. Okay. This is a Texas issue. Now, every state is doing basically the same process, just Texas is the top board of it. All right. They're the leader of violations of due process. Not giving legal advice is just my opinion, no more, no less. All right. But let's see here. Back down here a little bit. All right. We're going to do the intro because it's going to give information. If you guys want to check out this guy's YouTube channel, Randy Kelton YouTube channel, his web channel. All right.
Special guest that I've been waiting to get back on here for a while. He's the most super annoying human being on the planet, and you're going to love him. So, we're going to have some fun and talk about some very interesting things that Randy's been working on. Now, if you need help with your silver, you can call me anytime. Everything's in the description, and we still have plenty of those Trump bars. And Randy's even seen one of them. He even thought they were kind of cool. But let's go ahead and bring the most annoying person on the planet, Randy Kelton. Randy, oh, he is also the one who runs Rule of Law Radio, which you can hear Thursday and Friday night starting at 8 p.m. Texas time on ruleoflawradio.com. Now, Randy, how are you doing this morning?
I'm doing pretty good. I don't get headaches, and I don't get heartburn.
Until you're talking.
I'm a carrier, and I'm working on some heartburn. I am preparing a suit. I have someone who wanted me to help him prepare a suit in Austin, and the issues that they had coincided with research that I've been doing. Anyone who's in Texas who has ever had any dealings with the criminal justice system, also their issues also coincide with mine, because my research over the last 30 years has indicated that every step in the criminal justice process, from arrest to trial, is not only wrong, it is very specifically against particular law. And it's not just against particular law, it's against particular law for a very specific reason. Every step has been carefully crafted so as to put a person accused of crime in a position such that they have no option but to take a deal when it's offered. In state Texas, we have become the worst police state the world has ever seen. Communist China incarcerates approximately 121 people per 100,000. Russia, 327. The United States as a whole, 657. Texas, 840 and climbing fast.
Wow.
The reason this happens is the prosecutors in the state of Texas were told by the legislature that our police and lower courts, they're in need of legal advice. And since we already have learned counsel in public employ in the form of prosecuting attorneys, it would be a good idea to have prosecutors give legal advice to the police and lower courts. Well, that was a horrible idea. And a reasonable person of ordinary prudence could expect that that would lead to precisely the problem we now face. If you are charged with a crime, you will not be taken directly to a nearest magistrate the way 14.06 and 15.16 command an officer to do. An arrest without a warrant, 14.06, arrest with a warrant, 15.16. Both command the person to take them directly to the nearest magistrate, or 543.002 Texas Transportation Code. If you're arrested for a traffic violation, you are to be taken directly to the nearest magistrate. Not judge, magistrate. Now, every judge is a magistrate, but a magistrate only acts in a magisterial capacity when he's marrying someone, or marrying two people, not him getting married to them, when he's writing out a coroner's report, or when he's examining into the sufficiency of a criminal accusation in an examining trial. The reason they were created was so that if a policeman arrests a person for any reason, with or without a warrant, they were to take that person directly to the nearest magistrate and explain themselves. And it wasn't because they didn't trust the police. It was because they did not want the public to feel disenfranchised from the system. Well, in 1965, somewhere thereabouts, as best I can tell, because I'm having trouble finding the legislative history, there was an addition added to law. In 14.06, it requires the person to be taken directly to the nearest magistrate. In 1965, they added this subordinate clause. It said, or in order to more effectively provide the warnings in 1517, and those are simply Miranda warnings, the officer can take the person to...
I'm going to pause there again, okay, not giving legal advice, right? This is what I said in previous videos, right? You must tell the officer to take you to the nearest magistrate, whether it's 2 o'clock in the morning or whatever. If not, or you need to give him a notice. Now, right now, eventually, not right now, but I'm going to create a document of a notice to hand to the officer to direct me to the nearest magistrate, and write these codes up and all that kind of stuff and hand it to him. When he does not do that, that makes him liable of violation of due process. My opinion, not giving legal advice. Do not take it as legal advice. Do your own research.
Any other county in Texas. And there was an extra paragraph added to 1516 that said the same thing. Well, prosecutors looked at that and said, oh my goodness. Oh, it said, and the magistrate shall issue the warnings in 1517. So they said, oh goody, we don't have to bother with chapter 16 of the Texas Code of Criminal Procedure anymore. We don't have to bother with doing what's been in law since
Also, sorry about this again. Now, everything is based in criminal. Okay, so if you guys see this video, and if you want to give out this information to the cop watchers and to the auditors, right? Because they get arrested, they're under criminal things, but they've been taken directly to jail, right? Have them uh, fill out some type of form of notice of liability, right? Now, whether an attorney does it or whether they do it, you know, uh, get an attorney if you can to ghostwrite.
1215 AD, that has worked very well for us. But we can just take them through their butts in jail, drag them before a magistrate next morning, he'll read them their rights, and then the prosecutor can start in on his prosecution. He does not care if you are guilty or innocent. If you're guilty, if you are able to afford bond, he's going to call you in once a month and offer you a deal. If it takes 3 to 5 years, he doesn't care. He'll call you in once a month. And if you don't make a deal, he'll call you in next month and next month and next month until you make a deal. If you can't bail yourself out, then he'll throw your butt in jail. Contact you every month or so and offer you a deal. And he'll keep doing that and hold you in pretrial incarceration until you make a deal. That's why the average conviction rate in the state of Texas is 99.6. Everybody takes the deal. And every step in the process is horrendously illegal. And so after 30 years of researching this, something's horribly wrong here. We don't just have public officials doing it wrong. We have them all doing it wrong exactly the same way. And it's unreasonable to think that every prosecutor in every one of the 254 counties in Texas all came up with the same idea to do things the same way. I went to my JP, who is, I think Mark Autry would do what he thinks is right if it hair-lipped the Pope. And I laid out the law for him and compared it to what they were doing. And he said, Mr. Kelton, are you telling me that everything I did for 20 years as a peace officer and the last 12 years as a justice of the peace was wrong? Everything everybody in Texas is doing and has done for the last 30 years is wrong, and you're right. I said, don't ask me, Mark. I didn't write the code. I just read it. Here it is. This is what the clear letter of the law says. If a person is arrested for any reason, with or without a warrant, they are to be taken directly to the nearest magistrate by the most direct route. How hard is that to understand? Also, if you as a citizen take a criminal complaint that's complete in accordance with 1505, and what that says is a complaint in Texas must run in the name of the state of Texas. So it starts with in the name and under the authority of the state of Texas. And it must state that you have reason to believe and do believe that this person committed this crime. And you have it verified. You have your signature. You not verified. You have it authenticated. You swear to your oath, and they verify your oath. And that's complete in accordance with 1505, and it must accuse them of committing a specific crime. So if it's complete in accordance with 1505, and you give it to some magistrate, 15.09 says, when a complaint is forwarded to a magistrate in accordance with 1508, and that just means it's given to him, and it's complete in accordance with 1505, the magistrate shall issue a warrant forthwith. How hard is that to understand? It does not say may, might, or can if he wants to. It does not say he can examine into the sufficiency of the allegation. It says he is to issue a warrant. And when the person is arrested and brought before the magistrate, then both parties appear before the magistrate, and he holds himself in the examining trial in accordance with Chapter 16. This was put in law when Texas was created, and it's in Section 1, Article 1 of the Texas Constitution. And it's still in play because Section 29 says, in order to avoid the evils of the high powers in government, the rights and privileges included in this section shall be held inviolate in perpetuity. Telling all these public officials and legislators, don't screw with it. So, this is what the law says, but it's not what's being done. So, I am preparing a lawsuit. Most people who know who I am know I filed a 150-page criminal complaint against the governor for issuing all of these executive orders. The governor is the director of the executive branch. He can't talk to me. Now, a court can talk to me if I'm accused of a crime or if I file a civil action. The legislature can talk to me because they're the only ones who can write law that affect me. But the governor can't talk to me at all. Now, he can talk to the people that work for the executive branch, but not me. I don't work for the executive branch. The executive branch works for me. So he issued all these orders that ordered me around. And I said, where the heck did you come up with the authority to do that? Oh, well, it's an emergency. Yeah, so what? What's that have to do with anything? And that's exactly what the court said in the salon case. The woman in Dallas who refused to close her beauty salon, and they arrested her. And the court said that the Constitution is not abated in an emergency. So I accuse him of all these criminal acts. The district attorney, Jose Garza, was a Democrat. The governor was a Republican, so he gave him to the grand jury. Then the governor immediately rescinded all of them. But before that happened, I went down to the county courthouse in Travis County, and they wouldn't let me in without a mask. I went to the county first, and I got a sergeant, and I said, Sergeant, I have a medical condition. I'm a beat up old combat veteran, and I can't wear that mask. Well, you can't come in here without a mask. Well, then you need to provide some kind of remedy here. And he said, okay, if you'll wait right here, I'll go up and get the clerk and bring her down here. I said, that'll work. So he did. So I left there and went to the district court because this was the wrong court for me. And there's this little short bailiff there, a young kid, mid-20s maybe. He had what looked like military tats on him. So I figured he had just got out of the military and was pretty full of himself. And I told him I wasn't coming in without a mask. He said, well, you can't come in without a mask. I said, I see you're wearing a pistol. He said, yes, I am. Tell me, is that pistol loaded? He said, yes, it is. Are you prepared to use that pistol to keep me from coming in here without a mask? He said, yes, I am. Okay, then I need you to go up and get this clerk. I gave him the name and have her come down and talk to me. And he looked up at me and he said, was that an order? And I thought a minute and said, well, yeah, as a matter of fact, it was. He said, how's that worked out for you so far? Pretty good. You want to test it? He said, yes. I took out my cell phone, dialed 911. So I was blocked from going into the courthouse by a guy with a gun who threatened to use that gun on me. Now, maybe you all don't get too excited about that kind of thing, but I do. I think everybody should have guns. I think they are the remedy to all these gun problems. But I don't have one. I can't bring myself to put my hands on one. I spent too much time on the sharp end and too much time trying to keep people alive who has been on the sharp end. I won't have him. And for him to threaten me with a deadly weapon, that is a really big deal. So I'm suing the governor. Now I'm not against the governor. I actually like the governor. And I hope he understands when I sue him that I waited until he got reelected. And I have someone who called into my show and such, and she was going to Nordstrom Rack to do some shopping, and she has Lyme's disease, and it causes her some serious breathing problems, and she can't wear a mask either. So before she went down there, she called them and corporate and asked if she could come down there without a mask because she had a medical exemption. And they said, sure, we honor medical exemptions. Go on down, you'll be fine. Well, she wasn't fine. A security officer there wouldn't let her go into the changing room without a mask and grabbed her arm so hard she left her handprint in her arm. And the woman was also had been diagnosed with PTSD. And terrified her, she jerked loose and went into the changing room, closed the door, and dialed 911. Well, they heard her dial 911, so they did too. The police came, they took her outside, they're talking to her, one cop eases behind her, they jump her, tackle her to the ground, handcuff her, put her in the car, and they're over, got her car keys out of her purse and went over to search her car, and left her in the patrol car with the windows up and the motor off. A citizen watching, a woman watching, went over to the policeman and ordered them to get her out of the car because she was banging her head on the window to get somebody's attention because she felt her temperature rising. They got her out, called paramedics, and when the paramedics got there, her temperature was still 101, and they said that her blood pressure was off the charts. If that woman hadn't have had the courage to intercede with these police officers, she could well have died in that car. So, we have sued the state of Texas. This is what we're claiming. We're claiming first we're suing the governor, that the governor's executive orders were the proximate cause of her injuries because Nordstrom Rack only instituted these requirements because the governor ordered it, and the city council or mayor followed suit, and Nordstrom had to do this because of the governor's edict. But then Nordstrom didn't properly train their personnel, so they were a proximate cause of her being turned over to the police, and subsequently they were responsible, or at least partially responsible, for everything that happened to her. So to get her out of the car, and get the paramedics there and get her stabilized, and the policeman asked her if she wanted to file criminal charges against the security officer that grabbed her, and she said yes. The policeman immediately went inside and solicited criminal complaints from the security officer because they didn't want to have to explain why they tackled her and hotboxed her when she was the victim. So they went in, and we have it on video cam on their body cams on. The policeman pressured this woman to write a criminal complaint. So they write a criminal complaint against her. It's a Class C misdemeanor. And they give her a ticket. She goes home. She wouldn't take a deal. And she, I was helping her. And finally, after 2 years, they dismissed the case for, look for it, lack of evidence. She demanded an examining trial early on. They didn't hold one. Then 2 years later, they dismissed it for lack of evidence. Well, good luck, guys. So, this is what I'm claiming. First, under 1406, 1517, they're required to take a person directly to the nearest magistrate, but they don't. They take them to jail.
All right, so that get tied into there. Took a little extra minute on there. So we're going to go into the category of part 2. Okay. There we go. Part 1 to go. Of course, this is on my end because the way YouTube works. These will be the people news. Till next time. Bye, y'all.